Welcome to today's program titled COVID-19 Legal Exposure for Public Company Directors. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you're encouraged to submit questions through the conference by typing them in the Q&A text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread and it is required for the CLE credit. Copies of the webinar recordings and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Greg Markle. Greg, you may begin.
Thank you. Good afternoon. I am Greg Markell, and I am moderating today's webinar. The topics we will be talking about are identifying COVID-related litigation risks to companies and their directors and officers in the areas of securities class actions, breaches of fiduciary duty, and inadequate disclosure. Our panel will also talk about ways of mitigating those risks and avoiding liability. The panelists are my partners, each of whom is an outstanding, complex commercial litigator and trial lawyer, and each of whom has a specialty in securities litigation. Gina Ferrari is all of that and has been my colleague for the 4 years I have been at Seyfarth. We're happy to introduce 3 super litigators who joined us recently from Arlen Porter. They are panelists Vinnie Sama, Kate Schumacher, and Daphne Morduchowicz. This group has added great depth and expertise to our securities litigation group at Seyfarth, and which also includes a number of other outstanding securities litigators, including, among others, Will Prickett and Stephen Paradise. Before we start the program, I find myself unable to start it without mentioning the heroic work of our country's medical professionals who are every day putting themselves at risk. We all thank them for all they do, and in particular in the COVID area. The 5 of us are here to talk about what we know how to do in our area of expertise. So let's get started. Securities class actions in stock drop situations are very often high stakes because of the potential size of the stock drops. A rough measure of losses claimed is the decline in market cap caused by a misrepresentation or omission. Kate, what are you seeing in the area of traditional class action stock drop cases that are related to COVID-19?
Thanks, Greg. As everyone knows, the last month has certainly been a time of unprecedented social and economic upheaval, with markets plunging, recession looming, and businesses that seemed perfectly healthy in February suddenly on the brink of failure. Some would say those are optimal conditions for shareholder class action lawyers. And in fact, 2 COVID-related securities class action cases were filed on March 12th, and the third was filed on April 8th. These cases, one against Norwegian Cruise Line, one against pharmaceutical company Inovio, and the third against telecommunications company Zoom, targeted companies in industries that are, for different reasons, on the front lines of the COVID attack and outbreak. These cases also demonstrate categories of allegations that may well come to characterize the first wave of these COVID-19 securities class actions. So let's briefly just discuss these cases I've mentioned. So in the Norwegian Cruise Line case, plaintiffs allege that the company's February 20th, 2020 Form 8K and press release provided a misleadingly positive outlook despite the COVID-19 outbreak, and that its 10K, filed 7 days later, failed to disclose that the company was employing fraudulent sales tactics, including false statements by its sales force about the virus and its impact on the cruise industry to, according to the complaint, induce customers to continue booking their cruises or to refrain from canceling them. According to the plaintiffs, the truth only came out on March 11th when a Miami New Times article leaked emails from a cruise line employee concerning the company's sales practices. The company's shares fell 26.7% that day and another 35.8% the next. In the Inovio case, the plaintiffs claimed that the pharma company capitalized on COVID-19 fears when on February 14th, it announced that the company had developed a COVID-19 vaccine and planned to start human testing early this summer. The company's stock price allegedly more than quadrupled on this news from $4.28 per share on February 28th to an intraday high of $19.36 on March 9th. Then, on the same day, an activist short seller called for an SEC investigation into what it said were the company's quote-unquote ludicrous and dangerous claims, after which, of course, the stock price tumbled back down to $5.70. And then most recently, the third case was filed on April 8th against Zoom, a telecommunications company that provides virtual video conferencing services that, as you all know, is being widely used by organizations whose employees are working remotely. I'm sure everyone listening has been on their fair share of Zoom calls this month. And according to this lawsuit, Zoom, between April 18th, 2019 and April 6th, 2020, issued to investors materially false and misleading statements concerning the company's handling of user data and their overall security measures. The case alleges that as a result of the company's misrepresentations concerning its data security, those who use Zoom services were at an increased risk of having their information accessed by unauthorized parties. And the complaint stresses that usage of the service would likely have declined once the platform's data protection inadequacies come to light. So what do these cases tell us, if anything, about the likely targets of securities class actions related to COVID-19? The Norwegian Cruise Line case appears to prove out what, frankly, a lot of people have predicted, right? That certain industries hardest hit by the pandemic, like travel or hospitality, would be the first targets of these types of claims. The Inovio case, on the other hand, points up another potential risk that we're going to discuss later today, overly optimistic statements by companies in industries that are best positioned to benefit from the crisis. So pharma, medical devices, or even the telecommunications companies like a Zoom, which has clearly benefited from this crisis. But, really, given the breadth and scope of the companies affected by COVID-19, just about every public company in any sector of the economy could really be at risk.
So, thank you, Kate. Gina, what do you think will be the prevalence of COVID-19 securities class actions? Where do you see it going?
Greg, a month ago, I would say we'd see a trickle of cases because the pandemic is a classic black swan event. However, in the last few weeks, we've seen more than just these three cases that Kate has just highlighted for us. And I suspect that we're going to see a number more coming quite recently. It won't be a flood initially. It will evolve, just like the way our clients' businesses are evolving. And it's going to be different than the 2008 crisis because there we had investors feeling duped by the mortgage and financial industry because they felt like they were intentionally deceived. A global pandemic is unlikely to be pled as intentional and or foreseeable. We may also see some folks pulling back in suing companies that are hard hit by the global pandemic. However, I'm here to tell you I have yet to see plaintiffs' class action lawyers do so. And in fact, I think they see a little bit of blood in the water. Most importantly, is what's going to happen in the future. And we're going to talk about that today. So going forward, if companies don't provide adequate disclosures and controls, if they make misrepresentations about contingencies or exaggerated capabilities, we're certain to see more lawsuits. And I need to point out, just as we've seen in the last 2 years with a rise of event-driven D&O cases, I suspect that COVID will be the impetus for that event-driven litigation.
Okay, thank you. We also thought we'd talk a little bit in this section about M&A cases, which can be they can either be class actions or breach of fiduciary duty claims. But the question is a similar question with respect to M&A cases. How many will there be? Is this going to be a fertile area for those cases? And the answer is, I suppose, a partially yes and no question answer. Right now, the M&A market is slow. M&A companies just are getting used to getting used to their position in their own place. Companies that may engage in M&A are getting used to their place in the marketplace, and it isn't clear what their future is going to be. The M&A market does not like uncertainty, like most markets. It doesn't like high volatility in stock prices. And so the M&A market is slow, and therefore almost inevitably, there haven't been a lot of M&A cases that have anything to do with COVID. There's one company, Center State Bank, which was acquiring another bank, and it's been named in 3 lawsuits. It's a fairly typical inadequate price M&A lawsuit, but there haven't been, and one of those 3 lawsuits involving that acquisition does refer to COVID and inadequate disclosures relating to it, but that's about it so far. But what I think we're going to see going forward is probably going to be quite different. I think there is a good argument that a lot of people are making today in the financial world that we're seeing an entry into a recession or worse. That business will be bad for certain groups of companies, and that is going to increase the number of M&A transactions. Stronger companies will acquire weaker companies. Weaker companies will not have much of a choice about being acquired. It may be the choice of selling themselves or going into bankruptcy. And as that volume of M&A activity picks up, and it may not, but I would predict it will pick up over the rest of the year, there will be more M&A cases brought, and they will directly or indirectly relate to COVID, because COVID will have caused a number of those mergers by weakening the companies that are being acquired. In a number of cases, not all cases, there'll be normal mergers, but in a number of cases that will be true. One of the things that we can almost be certain of is that when there are a lot of mergers, there will be a lot of merger litigation if there is a public company involved. I'm going to go back just very briefly a little bit in history. So in around 2011 and 2012, there was a great pickup in the number of merger cases filed, and there were a small group of plaintiffs' firms who were suing on virtually every public merger that got announced. 94% of public mergers had a lawsuit filed with respect to that lawsuit, and a vast majority of those were resolved with disclosure-only settlements. Many of you probably are familiar with disclosure-only settlements. I'm not going to go into detail on it, but you will also know that the Trulia case put an end to disclosure-only settlements, at least in Delaware, where many of the cases were filed. That same group of plaintiffs' law firms shifted their attention in merger litigation from Delaware to other venues, many of them federal courts, some state courts outside of Delaware. And they began to use a new device called mootness fees, where they voluntarily dismissed their cases and there was no judicial review of a settlement. And they got attorney's fees and perhaps some minor disclosure, and the result is cost for the companies involved in the merger, cost for the D&O insurers, and legal fees for the plaintiffs. That abuse is still going on today. It is prevalent in the marketplace, and it is a way, and a very large number of public mergers have lawsuits designed to get mootness fees for the plaintiffs' lawyers involved, and it's a small group of plaintiffs' firms that are doing these. They will take over the space if the merger activity increases, and and they will come up with some theories about why the COVID incident wasn't properly handled by one of the companies, and they'll end up suing frequently, unless there's securities litigation reform, and that securities litigation reform can come in the amendment of the securities laws by Congress. Hard to get through, but possible. It can also come up in the context of judges putting out strong opinions disapproving of these kinds of abuses and abusive merger litigation, as the court in Trulia did. There also may be room today for companies to adopt bylaws and amendments to their certificates of incorporation in a way to help avoid those kinds of lawsuits. But one thing I think is very, very likely is that we will see more merger-related litigation in coming months, and it will be in some way often connected to the COVID experience of the companies involved in the merger transaction. So with that, I would like to turn over to Kate, a discussion of disclosure issues and how those relate to COVID-related lawsuits.
Sure, thank you, Greg. One potential area for liability for companies and their officers and directors is related to disclosure issues. So let's remember that timing-wise, significant developments related to the coronavirus outbreak followed or coincided with the release of fourth quarter and annual earnings information and investor calls for many companies. As a result, companies had to consider whether disclosures were required to address the potential impact of the outbreak on the company's future results or operations. Then, on March 25th, the SEC's Division of Corporation Finance issued Disclosure Guidance Topic Number 9, which provides detailed guidance regarding disclosure considerations for public companies affected by COVID-19. The guidance states that organizations must tailor company-specific COVID-19 disclosures and revise and update disclosures as facts and circumstances change. The guidance also reminds companies that while it is difficult to predict with precision the effects of COVID-19 on a company, management's opinions on COVID-19's likely effects and future impact on the company can be, and most likely will be, material to investment and voting decisions. The SEC provided an illustrative, but certainly not exhaustive, list of topics that each company will need to assess carefully in considering the effects of COVID-19 and related disclosure obligations. So let's run down this list. Operational disruption. So how has COVID-19 impacted your financial condition and results of operations? How do you expect COVID-19 to impact your future operating results and near and long-term financial condition? Liquidity issues. So how has COVID-19 impacted your capital and financial resources, including your overall liquidity position and outlook? And, consider with this factor the requirement to disclose known trends and uncertainties as it relates to your ability to service your debt or other financial obligations or to access the debt markets. Valuation of assets. How do you expect COVID-19 to affect assets on your balance sheet and your ability to timely account for those assets? Demand or supply issues. So do you expect COVID-19 to materially affect the demand for your products or services? Or do you anticipate a material adverse impact of COVID on your supply chain or the methods used to distribute your products and services? Internal controls. How have COVID-19 related circumstances, such as remote work arrangements, adversely affected your ability to maintain operations, including financial reporting systems, internal control over financial reporting and disclosure controls and procedures? And if so, what changes in your controls have occurred or are reasonably likely to materially affect your internal controls? Workforce or labor disruptions. So will your operations be materially impacted by reductions in workforce and productivity? Or are travel restrictions and border closures expected to have a material impact on your ability to operate and achieve your business goals? And lastly, cybersecurity threats. We all have heard and know that there's an increased threat with more remote working. And we know for a fact that the incidence of cyber attacks has been on the rise over the last month. So those are also things to be analyzed, and we're going to address those, I think, a little bit more later. So as I've said, the above list is illustrative. It is certainly not exhaustive, and the SEC encourages disclosure that is tailored and provides material information about the impact of COVID-19 to investors and market participants.
Vinny, could you give us some more insight into the SEC's role in setting disclosure guidelines and standards and where they're going on the COVID issue so far?
Sure. Thanks, Greg. The first thing I wanted to say, what Kate just pointed out, is that there's two aspects of disclosures that are obvious, but the SEC is looking at affirmative statements and omissions. So you have to be careful of what you say affirmatively and what you don't say. Because by issuing this guidance, I think the SEC is indicating they're going to monitor these disclosures very carefully, and they're going to take appropriate enforcement or other action if they see violations, especially because it's cut across so many different industries at this point. In the past, some of the topics that they've given guidance on are topics that they have given guidance on in the past as well. So if you look back in certain areas where they've given guidance on disclosures, particularly GAAP and non-GAAP disclosure guidance on products and assets in the financial services and insurance industries, what you've seen there is an uptick in enforcement activity later in time, which is coupled with private securities and shareholder-derived litigation. Some of the examples are turned around issues of guidance on timing of recognition of revenue, cost, and income from sale of businesses or assets, finite insurance transactions, repurchase transactions, as Kate alluded to, valuation of assets where they've given guidance on things related to mark-to-market on the assets. Also on use of special purpose entities and off-balance sheet transactions. All of those are areas where they've given guidance and they've been very vigilant in the past pursuing activity that I believe was contrary to the guidance. More recently, in the past few years, SEC has given guidance on cyber threats, cryptocurrencies, and the protection of retail investors. And all of those areas, you've seen an uptick in SEC activity with the related litigation that I mentioned. The overlay on this is also that in the past few years, particularly in the financial services and the healthcare industry, you've seen a significant increase in the whistleblowers program that the SEC has used to become now an important part of its enforcement activity. So given the situation with COVID-19 and individual companies' responses to that, you have to realize that if you have situations of disgruntled employees and their officers, and are simply employees that are running things up the chain based on their observations or what they sense or feel is happening, companies have to be very sensitized to responding to that in an appropriate fashion, because if it's not responded to in an appropriate fashion, those people may make it right over to the SEC. The last point I want to say on that is Kate alluded to materiality, and it's obvious, but it's both quantitative and qualitative. So it's not going to be the answer in this situation that we're in the midst of to say that we have this percentage formula, and if it's only going to affect X percent of a product or a line of business, then we don't have to disclose the issue. Rather, they're going to look at it holistically, and particularly with COVID, how it may affect not just the operations, but the employees, your controls, and your finances.
Great, thank you. We're now going to do a hypothetical, and I think Kate, if you would give the hypothetical, that would be good, and we'll then ask Vinny to speak first on the answer, and then Gina. But Kate, if you want to read the hypothetical,
Sure.
question, please go ahead. Thanks.
Sure. So the first hypothetical is Protective Wear, Inc., a Delaware corporation listed on the New York Stock Exchange, manufactures protective gear, including hospital-grade face masks that it advertised were 99% effective in shielding germs and viruses. Its factories are located all over the world, but its largest factory is located in Wuhan, China. What COVID-19 issues should Protective Wear think about as it makes its financial disclosures? So, Vinny, clearly there are going to be a number of ways this company will be potentially impacted by COVID-19. Do you want to run through a few things that you see from the hypo?
Vinny, are you on mute by any chance?
Yes, I'm back on. Can you hear me?
Yeah.
Okay, great. Yes, thanks, Kate. First, you will have issues of claims of the product efficacy that are being made by the manufacturer and their accuracy. And there's two components that there's a potential product liability issues of negligence and warranties, and then the associated securities liability exposure if those claims of product efficacy prove to be untrue or not completely accurate. You also have, in terms of with spike demand, you're going to have issues of pricing issues, at least the price gouging that people may allege. One of the other more practical aspects of that is also the creditworthiness of your customers and payment. Are you going to get paid for that? And the concomitant spike in demand, what is your ability to deliver those products either under the contracts that you have or the terms that you've agreed to at the time? Those are some. I'm sure Gina could add a couple others.
I would dovetail on that and say that you're going to have similar liquidity issues if there are factory shutdowns and supply chain issues, each of which Kate noticed or talked about when she was talking about the SEC recommendations and guidelines. And it would also trigger an adequacy of worker protection and an impact of potential disruption of workforce, again, which all leads to the liquidity of the company and the health of the company.
All right. Thank you very much. Very good. So, Daphne, it is now your turn. We've been going a little while, but you haven't had much of a chance to speak. We're going to turn to a discussion of some legal issues and specific recommendations regarding disclosures, and start off with forward-looking statements. And the floor is yours.
Thank you, Greg. First, I think before making any disclosures, each company needs to carefully assess and expand the list of risk contingencies and be very careful to distinguish between contingencies and issues that have already begun to materialize. And where possible, with respect to material risks, the company and its officers and directors should document that a plan is either in existence or is being worked on to deal with the risks. When making disclosures, it's important to use clear language to identify predictions or forecasts and to indicate that they're uncertain. As a general matter, statements clearly identified as forward-looking and accompanied by meaningful cautionary language are not actionable under securities laws. Forward-looking generally means projections of future events or expected future revenues. Where it gets tricky, though, is where the future projection is based on a stated present fact. So, for example, a court held that a company's statement that it is on track to achieve certain results was not forward-looking, but was a statement of existing fact. So in order to be protected, there must also be meaningful cautionary language. And what does meaningful cautionary language mean? Courts have held that cautionary language must identify important factors that could cause the results to differ from the projections. The cautionary language should be substantive and tailored to the projection at issue and industry or company specific. Vague or boilerplate language, such as all businesses are risky, has been deemed insufficient. Courts have also held, though, that cautionary language that remained the same over a long period, despite changes in the issues the company was facing, was insufficient. Here you have the statement, COVID-19 poses a risk to all businesses, without identifying what specific area in the particular business the risk relates to, and this may not be enough. In this example, we have the CEO of the company saying, we face the risk of operational disruptions due to potential factory shutdowns or decrease in available workforce. The cautionary language on this slide specifying the risk to the business from COVID-19 would likely be considered meaningful. Note, though, that courts have made clear failure to predict the particular factor that ultimately causes the results to differ from what was projected doesn't mean that the cautionary language was insufficient. So in this example, if the company faced operational disruptions from some unforeseen impact of COVID-19, not the factory shutdowns or the workforce disruptions, that wouldn't necessarily render the cautionary language insufficient.
So I'm going to turn to Vinny in just one moment, but I would like to make a comment here, which is some of these concepts, which are concepts that come out of securities law cases which have nothing to do with COVID, they've been around for years. Forward-looking statements is a prominent one, often now in the past dealt with projections and that sort of thing. But given the fact that we are now in territory that none of us have ever been in before, it's unique, it's a black swan, there are people people are going to have to make projections about the future where they don't really know what's going to happen. They can only give their best informed guess as to what's going to happen. And so the kind of discussion that's going on here about forward-looking statements is extremely important when giving guidance to those people who are spokespeople for the company or are the senior executives of the company who have to talk about where the company is going. They have to understand some of these concepts that are being explained, like forward-looking statements. Vinny, what are your thoughts on the best practices to get whatever safety one can get when making forward-looking statements?
Sure. Thanks, Greg. First, as you just highlighted, this is a very important concept, and I think often overlooked concept in securities law. This can provide a company with a significant amount of protection, the forward-looking statement. And given the COVID-19 situation, I think what you have to do is first be as specific as you possibly can under the circumstances about the risks and contingencies that you are facing and the models that you look at, how it will affect your business. And a subset of that specificity is that you really should look at all the items that may negatively affect the future operations of the company and the financial performance of the company. And look at those and put in, obviously you cannot flood the forward-looking statement with everything, but identify the critical ones and put them in there with the right cautionary language. Because there's also a number of federal courts I've seen across the country, particularly out west, where the courts will look for every opportunity to find a deficiency in the forward-looking statement, really all in the view to try to protect the investors. So I think you really have to look at that carefully. Don't have it as a sort of perfunctory exercise. It should be a very serious exercise. Do it thoughtfully with the specific language, and I think you'll get a fair amount of protection out of that going forward.
Great. Daphne, back to you. What about the concepts of puffery and opinion statements? These are also, I think, relevant in this black swan era.
I think that's right. Another issue to be mindful of is not overpromising, particularly in this uncertain environment. Courts have deemed certain general statements of corporate optimism to be non-actionable puffery. These include statements like, we have confidence in achieving our full year guidance for revenues, or we feel really good about where we are today. Here we have the CEO saying we are confident in our ability to survive the crisis. This general expression of confidence in the company's ability to manage the crisis would likely be non-actionable puffery, assuming the company is not on the brink of bankruptcy. But with puffery, you still have to be careful about the disclosures because misstatements of existing facts are actionable, even if arguably puffery. So in the example we just looked at, if the company was on the verge of collapsing, a statement of confidence in its ability to survive the crisis would likely be considered actionable. For example, the statement that a company's inventory situation was in good shape or under control when defendants knew the contrary was true was held to be actionable. So in this slide, we have the CEO saying, we expect our new plant to immediately begin production of our product. But then we have the plant manager reporting difficulties ramping up the new plant for large-scale production. The CEO is expressing an optimistic, forward-looking statement about a particular plant's readiness to begin production. It's pretty specific and not general puffery. And then it's also undermined by what the plant manager is reporting. So the statement could be actionable depending on the circumstances.
Vinny, do you have any additional suggestions on how to protect these types of statements?
Yeah, I mean, the observations I would add to Daphne are obviously, first off, the context of the statement is key. The context in which it's delivered and the context in which the company is operating. And as a general rule, the more general or broad the statement is, the more likely it will be considered puffery and not actionable. But you oftentimes will get into more specificity, but when you do that, here's where the challenge comes for the company, because you have to make sure when you're making that statement that the company is not aware of any information that's inconsistent with that statement. So, and that sounds very obvious, but oftentimes you have high-level executives that are making these statements, and you have to make sure that the information beneath them is properly brought up to their attention so that the statement could be crafted to be consistent with the actual information available.
Good, thank you. Daphne, how about statements of opinion by spokespeople and top executives?
Right. So in 2015, the Supreme Court in Omnicare held that sincerely held statements of pure opinion don't give rise to strict liability under Section 11 of the Securities Act. The court concluded that a statement of opinion doesn't constitute an untrue statement of material fact unless the maker of the statement doesn't have the subjective belief he espouses, or the opinion contains embedded facts that are untrue. Following Omnicare, courts around the country have held that Omnicare also applies to claims under Section 10B and Rule 10b-5 of the Securities Exchange Act. Courts have not consistently applied Omnicare to Section 14 claims under the Exchange Act, but that might change as more cases come before the court. Following Omnicare, courts have made clear that an opinion often involves the analysis of competing facts, and investors don't expect every fact known to the issuer to be disclosed. The Supreme Court noted a statement of opinion is not necessarily misleading when an issuer knows but fails to disclose some fact cutting the other way. The court explained reasonable investors understand that opinions sometimes rest on a weighing of competing facts. So, following Omnicare, courts have identified 3 categories of liability with respect to opinions. A material misrepresentation theory, where the plaintiff must allege both that the speaker did not hold the belief professed and that the belief is objectively untrue. Falsity of opinion claims, based on allegations that a statement of fact contained within an opinion is materially misleading. This requires the plaintiff to identify and allege that the supporting fact the speaker supplied is untrue. And then an alleged omission theory, where plaintiff has to identify omitted facts that allegedly undermine the opinion and make the opinion statement materially misleading to a reasonable person reading the statement fairly and in context. So here we have the CEO saying, we're implementing safety measures at our factories and believe that our workers are adequately protected. The statement regarding the adequacy of the workers' protection is an opinion, but you have a worker reporting the factory is overcrowded and there's not enough protective gear to go around. So really, depending on the extent of the reports from the workers that they don't have sufficient protective gear, this could be an actionable opinion statement.
So, Gina, I don't know if you have any comments on the opinion statements or not. If you do, please give them. But I then think what we might do is go directly to the next section, Gina, breach of fiduciary duty claims. We're about 44 minutes in, so we have about 16 minutes to go, roughly. So I think we should probably do those 2 things. So if you have comments on Omnicare, you let us know those, and then go on to breach of fiduciary duty.
I think it makes sense, considering the time period we have left, to move on. And at this time, I will provide the CLE code for everyone. When you fill out your form, the CLE code you will use is S as in Sam, S as in Sam, 9002. That's SS 9002. All right. So, are we ready for me to move on to the fiduciary duty claim?
We're ready. We're ready for breach of fiduciary duty claims.
Great. As folks know on this phone call, the directors and officers of a company owe fiduciary duties to the company and their shareholders. Those duties include the duty of care, which is reasonable care and reasonably informing yourself, and the duty of loyalty, which is to be disinterested in the outcome of the transaction. So what we would like to focus on today specifically are the oversight duties arising out of the Caremark case and cases since then that people should be focused on in the COVID era. So I suspect that everyone who's listening already has a task force or has created committees that are related to COVID. And what's important is going to be the follow-through, as you're going to see from the next few slides that I talk about. And to answer questions that I'm seeing come in, I believe that if folks don't follow Caremark and the following cases out of Delaware in both their monitoring and implementation, we're going to see an uptick in Caremark-type cases. It will take a while to play out unless something catastrophic happens because of a failure to implement and follow those controls in a reasonable manner. So let's first talk about Caremark. Caremark is a seminal case on corporate law that came out in the 1990s from Delaware about the duty of care. And it's about what's the responsibility with respect to the organization and monitoring of the enterprise to assure that the corporate functions within the law and to achieve its purposes. And Caremark came out and set up a number of standards. And they're standards of reasonableness and good faith to help guide boards in their duty to oversee the company. So there needs to be appropriate internal reporting systems in place so that appropriate information comes to the board in a timely manner. And those controls need to be implemented and monitored with a reasonable system. We're talking about process, and we're talking about following through with process. There simply needs to be a good faith effort to monitor and exercise that oversight. And for that reason, historically, Caremark-type claims have been very hard for plaintiffs to prove. The plaintiffs actually need to prove that the board acted with bad faith. As to two prongs, if you were looking at the Caremark holdings. The first is a standard, the first prong is a standard to adequately and reasonably implement reporting and information systems and controls. And I'll talk to you about what came out of the Delaware courts in 2019, analyzing that first prong in just a moment. And the second prong is once you've implemented a system of controls and reporting, are you actually performing the tasks of monitoring and overseeing the operations such that the board is actually informed of the risks, the red flags, the yellow flags that require their attention? So where I see next steps for board of directors at this point in time is whatever you've already set up, you need to follow through, and you need to make sure that you're getting the type of information that allows you to act on any of these red flags, and or once you've delegated reasonably to get reports back from the experts within your company, you are actually getting that information and acting upon it. So let's look at this first prong in implementing the reporting and information controls. What Marchand says, which is a 2019 case out of Delaware, is you need to do a number of things, and we've listed them here on this slide. That case came out of a company that was alleged to have failed to monitor their food safety compliance there was a listeria outbreak and the company was forced to shut down, which then forced a liquidity crisis. And as I'm sure you can imagine now through our presentation, there could be a number of situations where COVID does just that, shuts down the company or supply chains, or reduces personnel, and or creates a liquidity crisis. And what the court said in Marchand was, you can't just have the existence of a monitoring or control system. It needs to be effective. So what does it mean to be effective? Well, you should establish committees. I suspect, again, that folks have already established committees. And then follow through with protocols requiring management to keep the board apprised of the compliance practices, risks, and reports. Again, it just needs to be reasonable. It does not mean that each director and officer needs to be the expert on each of these issues. We just need to set up controls such that you're getting the right information. You should have board meetings, and in this COVID era, they need to be more frequent and regular. They need to be set out, and you need to set up a process for what's being reported, the procedure for communicating up and down the chain of your company based on red and yellow flags. You should have regular discussions about the compliance risks that are related to COVID. And a note about meeting minutes. So Marchand talks about meeting minutes. I've talked with Greg in advance of this presentation, and we both believe the continued practice of board meeting minutes that are broader, yet attach specific documents that relate to the issue are probably still best practices. All right, let me just stop quickly at Clovis Oncology, which came out of Delaware soon after the Marchand case, which is related to a cancer drug from a pharmaceutical company. And in that case, it really looked at the Caremark prong, second prong. And what they found was there needs to be a means of acting and setting up systems so you can actually identify these red flags and next steps that I just talked to you about when we were talking about Marchand. The board received reports of red flags and either ignored them or didn't have the type of information they needed to act to appropriately run the business. And so that's why I continue to stress where I think the future of these claims is in how companies and boards act moving forward just as COVID continues to change and shift. Our boards need to, and our officers and directors need to be facile and informed. So I mentioned this earlier in the presentation, event-driven litigation, and this is another area where we think that COVID-related cases are going to push for a rise in D&O claims. We've seen in the last 2 years simply an event occurring setting the impetus for plaintiffs filing a large number of cases. And those come out in the Me Too claims, cybersecurity, potential privacy claims, disappointing financial results, operational difficulties, or the mere fact that there's been an IPO. And event-driven litigation is different than what we have historically seen, because in many situations, there doesn't even have to be a loss, there needs to be a potential loss. And I think COVID is going to be the impetus for some of these event-driven cases. Just look at the Zoom case that we talked about earlier. If you heard Kate, she specifically said the allegations in that case were there was an increased risk of having information accessed by unauthorized parties, and usage of the service would likely decline once the platform's data protection inadequacies came to light. That is an example of this event-driven, non-apparent or non-immediately apparent loss type of claims that we have seen skyrocket in the last 2 years. Things you should look out for, types of cases you should look out for. are going to arise around insurance coverage changes, regulatory changes, and certainly around the CARES Act. And we have 5 more minutes, so I will just preview a number of things that will actually be part of 2 follow-on presentations from Seyfarth on COVID. So as the pandemic is changing, there is a lot of uncertainty in how to underwrite these types of claims, what the price of the insurance will be, what exclusions are going to apply. And for that reason, we suggest for anyone who's looking to renew their policies, you build in a lot of time and you work with your broker. You should start the process earlier than you have been. Again, this is very similar to other event-driven litigation. It's tough to underwrite these claims, and it's tough to price these claims. It's not clear yet, as the crisis evolves, which of the exclusions might apply. Folks are currently looking at bodily injury, pollution, E&O exceptions, and whether or not there may be exceptions to that on Side A losses. And of course, we're going to see as this progresses how D&O insurance works with other insurance. I want to stress really quickly insolvency issues. Folks need to start worrying soon. Yes?
Gina, can I just interrupt for a second? So is a panel relating to the D&O issues one of the 2 that you were referring to earlier?
Yes, I'm sorry. So one of the 2 upcoming panels will be about D&O insurance considerations, and the second will be about insolvency duties and considerations. So if you look at the 2 bullet points on this slide, those are the 2 I'm referring to. Moving towards the second, insolvency concerns, you don't have to be insolvent for there to be duties to creditors in certain states. So there needs to be a consideration that in certain states, you cannot wait for a bankruptcy filing to start worrying about fiduciary duties to creditors and shareholders. So the question of being in the zone of insolvency will arise under different circumstances in different states. And as we're unfortunately seeing a number of financial problems, especially in certain industries, is leading towards insolvency and bankruptcy, and we'll be talking about that in a future webinar. With that, all right. I will move on to the takeaways, Greg.
Yep, that's fine. Go right ahead.
I understand that.
Tell you what, let me just make, sorry, let me interrupt you for 1 second. So for the audience, you'll have met your hour in about 2 or 3 minutes. We're going to probably run, in order to get through the takeaways, which I think are important, probably another 5 minutes past that. You're not required to stay for it in order to get your CLE credit, but we'll probably run a little bit over. Go ahead, Gina.
Sorry, I'm actually going to kick it back to Kate to start off with the takeaways.
Well, the takeaways are structured. We're going to do the board takeaways perhaps very briefly, unless you think you've covered them, and then Kate will do the next section.
I apologize. The first takeaway slide is mine because I've just talked about
right.
the duties of oversight. Thank you, Greg. So
right.
Folks need to look really closely at cybersecurity protections, and not just in the context of being hacked. We're already seeing what's happening with Zoom. So any types of breaches, and have meetings on those based on what's now happening and the further risks of remote working. Again, information flow and increased meetings need to occur, and they need to occur in a planned way with follow-through so that directors and officers can actually monitor and implement controls. Succession planning, unfortunately, is an issue. to the extent that there are personnel that are sick within the company and cannot work, there needs to be plans and processes put in place for different people that will take over so that the company can continue moving forward. I've already touched on some insurance policy issues. I think the main takeaway there needs to be that if you are a company and you're looking at renewing your policy, please start that process early and know that there's going to be evolving case law as these claims move forward and as the crisis evolves and as the claims evolve. Active liquidity and debt management is important. This is not just the point I made on insolvency and bankruptcy. The oversight, the committees, the meetings that need to occur under Caremark need to also address liquidity and debt management. They need to address worker protections, and of course, all of your internal controls should be documented. Again, we want to stress this is a reasonableness standard, reasonableness standard that is relying on the experts within your company to report to you so that you are informed as a director and officer and then can meet your Caremark standards.
Okay. Well, thank you for that. And now, Kate, do you want to pick up on risk factors relating to company risks?
Sure, thanks. So real quick, as we've discussed, companies and their directors and officers need to carefully assess the company's risks. So there are always fundamental risks to consider, but there are also industry and organization-specific ones, and now there are COVID-19 related risks. And as always, it's important to distinguish between contingencies or potential risks versus risks that have actually already materialized and would have to be disclosed.
Okay. Vinny, do you want to pick up from there?
Yeah, the only I guess few points I would highlight what people have made already is that in terms of the control, I think periodic testing of what you're monitoring is important both in the IT, security, finance, and other control area. And the last is, connect this to some of the comments I made, is I think it's important to have the appropriate and robust information flow getting to the right people so a reasonable and informed decisions can be made.
Great. Thanks very much. All right, Daphne, do you want to wrap up with the final few points?
Sure, very quickly. I think everybody has to be careful to adopt the habit of using language that identifies predictions and forecasts in financial statements and indicates that they're uncertain, particularly in the context of the current crisis. Then opinions should always be identified as such, and they should be supported by facts. They shouldn't omit or conflict with information that would render the opinion misleading. And forward-looking statements should be carefully identified and should include appropriate and specific cautionary language and identify the risks and contingencies.
Okay. Well, I want to thank the audience for joining us today. I think it was the panel, I think, enjoyed giving these talks. I think we all learned something on the panel in the process of putting this together and listening to each other. And I hope the audience feels the same way. So thank you again for joining us, and
I think someone is asking about the code again, too. Someone is asking if you could repeat the code, the CLE code.
Sure. SS9002.
SS9002. So everyone, have a good rest of the day and be safe, and we hope to see you again in a future webinar, or you can hear us again in a future webinar, more accurately. Take care.
This concludes today's webinar. Thank you for attending.